Hi everyone, Assalamu alaikum and welcome to my video again. In my previous video, I was trying to focus on the cross-border international commercial agreements, and I was trying to focus on the practice in USA jurisdiction, and today I'll try to focus on the UK jurisdiction. And actually I'm talking about the contracts that we enter into for big purposes like construction of highways, purchasing or hiring aircrafts, ships from abroad, and producing medicine, vaccine, etc. These are the big contracts that we enter into, and I'm talking about all this. There are some small contracts that we enter into each and every day, every hour. We just put a click on the laptop and we give a order to the foreign supplier, and the supplier send me the goods, and I pay the money through LC. And for also for the small contracts, they should know these basic things of entering into contract with cross-border counterparties, because sometimes after receiving the goods the parties find that the goods are defective, and in that case they should know what kind of remedies they have, which forum they should move, etc. So to start with the jurisdiction of UK, first of all we can look at the provisions relating to battle of forms. Battle of forms, as I have said earlier, that this is kind of offer and acceptance and counter offer, counter acceptance, and these are the things that takes place in entering into cross-border commercial agreements. In UK jurisdiction, we can see that the courts will look at the last shot given by the party, and after that the performance of the contract starts, and the other party accepts that this is the way. So last shot provision is prevailing in the UK jurisdiction to find out when to start the contractual obligations. And it is generally seen that the supplier has the upper hand in this case of controlling the contract, because the way of sending the goods to the foreign country is totally in the hand of the supplier. The supplier can say that okay, you don't agree, so I'm not going for this contract, because I have my own procedure of sending the goods to your country. So in UK, it is seen that generally the suppliers win the battle. To talk about the language, we can see that in UK there is no legal provision that you have to write the contract in a particular language, but most of the international agreements are written in English. And in case of online contracts, there is no problem for entering into contracts online, which are also known as the B2B contracts. The main thing is the elements of the contract should be there. That is offer, acceptance, consideration, intention to create a legal relationship, certainty of terms. These are the basic elements of contract, and if these elements are present, there is no problem. There are legal relationships, and the contracts will be enforceable in the court. It may sound surprising that UK is not a signatory to Vienna Convention. Vienna Convention is all about Convention on International Sale of Goods, but Section 1(1)(b) of the Convention says that if the private international law of a country who is not a signatory to this convention, if the private international law says that the laws of the counterparty will apply, then the provisions of the CISG may also apply in case of a contract of sale of goods where one party is a signatory and another party is not. So in case of good faith, it is seen that in UK there is no legislation regarding this, and there is no obligation to put a good faith provision in international commercial contracts. But it is seen that from the Middle Age, a good faith is the essence of international commercial transactions. In the English courts, there were a lot of international commercial disputes, and the courts always tried to resolve this problem very easily. The courts have always tried to make international commercial transactions comfortable, easy, accessible for all the parties from the whole world, and this is the way the international commercial transactions is taking place. In some other countries, we can see that still today the judge of the international commercial court is not a judicial officer or is not a service judge. He is a business person or a person expert in the field of international commercial transactions. And for this reason, we should keep in mind that the international commercial transactions and litigation system should always be kept easy, accessible for everyone in the world, and it not go into very deep and complicated legal debates. And it should also look at the previous decisions and resolve the problems as soon as it possible, because in monetary matters, the when someone is filing a suit for money and he's not getting the money and is taking a long time, the business of the person can be destroyed. Um, in case of automatic termination, the parties have some right in some jurisdictions, and in some other jurisdictions, the parties' rights in that case of insolvency and financial distress of the other counterparty is very limited. Even in UK, we can see that in case of insolvency, the English law says that the other party cannot terminate the contract solely based on the insolvency of the counterparty. But in case of financially distressed matters, the other party has the right to terminate the contract, and there is no restriction or legal obligation in this case. So we have seen that in case of USA, we said that in case of insolvency, the practice in USA is that if the insolvent person goes to the court for insolvency litigation, then the other party cannot terminate the contract. But if the other party doesn't go to the court and sit idle, then the other party may have the right to terminate the contract very easily. If we talk about the rules relating to force majeure, you can see that fire, flood, war, these are the events that are granted as force majeure. Although the idea of force majeure is coming from the civil law countries, but in common law countries, the agreements keep these provisions on force majeure. Subcontracting without consent is very important. We have also seen in USA jurisdiction that whether the parties are given the right to subcontract. Yes, both in USA and UK jurisdiction, the parties are free to enter into subcontract with other parties without the permission of the counterparty. But the thing is, if the subcontractor is liable to send me goods and he's not sending me the goods within the time, then I can file my counterparty to compensate and put him in the legal arena. Assignment of rights and obligations regarding this thing in UK jurisdiction, the English law says that the parties can assign only the rights and not the obligations. And in UK jurisdiction, if the party wants to assign the obligations, he has to enter into a separate contract for that, and only he can assign the rights. And in case of obligation to assign for supply contracts, it is seen that the UK has a provision, section 136 of the Law of the Property Act, which says that the assignment must be in writing and signed by the assigner, and must be absolute. Written notice must be given to the counterparty. So these are the provisions are existing in UK regarding assignment. The third party has some rights in UK. Generally, we know that according to English rules of contract, only the parties to the contract can enforce the legal provisions, legal rights, and the third party don't have any right here. And this is known as the privity of contract, that only parties have the rights and obligations. But UK has enacted a law named the Contract Rights of Third Parties Act in 1999, and this law creates a statutory exception to the doctrine of privity of contract and provides the third party certain rights to enforce in the court. But in this wake of enactment of the Contract Right of Third Parties Act 1999, the third party cannot become a party to the contract automatically. Regarding choice of law clauses, we can see that there is no statutory provision to restrict keeping foreign governing laws in the agreements, and we can see that the parties are free to think about it and put their provisions in the contract. The English courts are recognized throughout the whole world. You can see that in case of enforcement, recognition, and enforcement of foreign judgments in USA, we can see that the USA courts recognize and enforce the English decisions very easily. They don't go for the filing a suit anew and go for the total legal procedure. They just implement and enforce the judgments of English courts. The UK is a signatory to the New York Convention. Bangladesh is also a signatory to New York Convention, but the law in UK is better than Bangladesh, because in Bangladesh we are facing some problems regarding implementation of the interlocutory orders from the international arbitration. That is, in UK, arbitral awards and interlocutory awards coming from foreign arbitrations can be enforced, but in case of Bangladesh, only the arbitral awards can be enforced in a civil courts, but the interlocutory orders cannot be enforced. So there are some cases, and the Supreme Court of Bangladesh has provided very elaborate discussions, and the discussions are also going on right now. I think that the government of Bangladesh will think about it, and the judiciary of Bangladesh will come to a solution to solve all these problems regarding international commercial arbitration, and make this country a good place for international commercial transactions, and the foreign countries will be attracted to invest here. Bangladesh is developing very fast, and it is recognized by international bodies like international organizations, JP Morgan, Goldman Sachs, and these investment banks are also looking for a good environment in Bangladesh to invest here. So this is all for today. Thank you very much for staying with me, and Assalamu alaikum again.